Good evening, ladies and gentlemen. Before we begin, let me introduce some members of the town government that act as advisors to this board. To my left is Martin Simon. To his left is Matt Collado. To his left is Matt Mazzaros, both planners in the planning department. To his left is Sabrina Butita, who is an environmental analyst with the Department of Environment and Waterways. You are here this evening seeking relief from the town zoning ordinance. New York State statute requires that any town that adopts zoning must also have a Board of Appeals to act as a relief valve, so that persons can seek relief without the expense of legal proceedings. The most common kinds of applications before this board are area variances. Area variances deal with dimensions of lot area, frontage, height, setbacks, and parking reductions. New York State statute mandates that the board must consider the following 5 criteria when evaluating variances. When you come to the podium to present your application, please do your best to address these 5 criteria. They should be on a sheet right up there on the podium. First one, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Whether the applicant has other feasible alternatives, whether the variance is substantial, whether an adverse impact on the environment will be created, and whether the alleged difficulty is self-created. This board also has the authority to grant special exceptions, also known as a special use permit or a conditional use permit. This is a use that is permitted by zoning, but under specific conditions designed to ensure compatibility with the surrounding area and the overall zoning plan. If all of the general and specific standards are met, this board must approve the application. If they are not, this board must deny the application unless they request variances. At that point, the 5 considerations and the balancing test shall be applied. What is the balancing test? The statute requires that the board balance the interest of the applicant and those of the neighborhood or community. The board shall grant the minimum variance it deems necessary and adequate, while at the same time preserving and protecting the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions that relate to the variances. Regarding procedures, cases will be called in order that they were advertised. When your case is called, please submit your affidavits and mailing receipts to Mr. Collado, and then the applicant will be given the opportunity to explain why the variance is needed. Again, please address the 5 criteria. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity to be heard. Please organize your thoughts and keep your remarks factual, related to the case, as well as the variances being sought. The board will then close the case and reserve decision. After all hearings are closed, the board will review cases and decide some of them, and others will be decided at a later date. There are 3 ways to find out about your case. The first is you can wait until after the public hearing, but there's no guarantee that we will act on your case tonight. The second is to check the website after 11 a.m. tomorrow. The third way is applicants can wait and be notified by mail. After the case is closed, no additional information or testimony can be submitted. No adjournments tonight, correct?
Just 521 property management.
All right, so that was the last one.
Yes.
Case 19288, 521 Property Management LLC, 521 Jericho Turnpike. Is anyone here to hear that one? That one is going to be adjourned. Do we have it? I guess we'll leave it open. The date? Or just push
What do
it
you
out
think?
until February?
To February?
Yeah, what's our first meeting in February?
You have the February 10th and 24th.
So we're going to hear that one on February 10th, 2026. All right. Now on to the cases.
The first case on the agenda is case 19435, Brett Little. The location is 1 Yellow Brick Road in Fort Salonga, located on the northwest corner of Meadow Glen Road and Yellow Brick Road in Fort Salonga. The property is zoned R43. The request is a variance to reduce the front yard setback on Meadow Glen Road from 10 feet to 0 feet for an existing 6-foot PVC fence and 6-foot chain link fence on a corner lot.
Good evening.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've submitted the affidavits of posting and mailing to Mr. Mazzaros. This is a large piece of property in Fort Salonga, Yellow Brick Road and Meadow Glen Road. And it's a corner, so no matter how large a piece of property is, when it's a corner property, it creates somewhat of a dilemma because there are, as the board knows, 2 front yards. So while it may be an asset if you live in New York City and you have no backyards anyway to have a corner property because you have light and air on both sides. When you're out on the island, and even though you have an acre of property, when you have a situation where it's a corner, I'm repeating myself, as the board well knows, you have 2 front yards. So we have a fence that on Meadow Glen Road, the fence, it's a 6-foot fence. We could have put a 4-foot fence, but one of the things I'd like the board to, it's really not shown on the survey, is from the road, from Meadow Glen Road, the property dips down. So if he would have put a 4-foot fence there, it really wouldn't be any protection to my client. So he did put up a 6-foot fence. It is on the property line. However, when you look at the impact on adjacent properties or the neighborhood, there really isn't any impact. It's set back. It's not right to the corner of Meadow Glen and Yellow Brick Road. It's set back very far, so there's no sight distance problems for anyone navigating Meadow Glen to Yellow Brick Road. So, and 2, whether the variance is substantial. Well, it seems substantial, but since, as I said before, this is a corner property, it becomes very problematic if you want to have a swimming pool or other things, you know, protected from the outside, which again is a requirement that the pool be fenced in. So it becomes very narrow, an area that you can actually use for your use of the rear yard. The benefit, whether it can be achieved by an alternative, well, I guess the only thing that he could have done is maybe push the fence back further, but that's not going to give any kind of use of his property within that area. And again, the board should recognize, or at least I'd ask him to, that there's no sight distance problem. When you come around Meadow Glen and turn on Yellow Brick, if that's where you're going, you have plenty of sight distance. You can look at the survey and see that it's probably a little more than half of the road frontage on Meadow Glen. Whether it be an adverse effect on the environment, we don't think so. It doesn't have any impact on the neighbors, and my understanding is he did do plantings in the front of the fence. Whether the difficulty was created by the applicant, well, I can't say that he didn't create the fence and didn't put it up. However, in this situation, I think the board should look at the entire picture and grant the variance, as again, this is a front yard, and when you have a front yard on Long Island, all you do is, 2 front yards, I'm sorry, all you do is have problems. So we ask the board for its favorable consideration. Thank you.
Thank you. Anyone on the board have any questions or comments?
No, thank you.
No.
No? Planning?
No, thank you.
Sabrina?
you.
Would anybody in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
We got a motion and a second. All in favor?
Aye.
Case is closed. Thank you.
The next case is case 19436, the Chaz Smithtown LLC. Location is 730 Smithtown Bypass in Smithtown. It's on the north side of Smithtown Bypass, 810 feet east of Terry Road. Property is zoned LI. The request is a variance to increase the max area of a ground sign from 32 square feet to 57 square feet for a proposed illuminated ground sign, that's sign 3. Increase the max height of a wall sign from 15 feet to 25 feet for a proposed illuminated wall sign. That's for signs 1 and 2. Increase the number of wall signs from a max of 1 sign to 2 signs. That's for sign 2. And to permit a wall sign not to face a public street. That's for sign 2.
Good evening. My name is Johnny Sabaro. I'm an attorney with Sabaro Law PLLC with an office at 6319 Northern Boulevard in East Norwich, New York. Thank you all for having me this evening. Here presenting with me is Andy Beckerman of Display Makers, Inc., and the requested application relates to the proposed installation of 3 signs at 730 Smithtown Bypass, which is the former Carrabba's Italian Grill location on Nesconset Highway or Smithtown Bypass. The property has a lot area of approximately 165,000 square feet, 3.79 acres, and it's designated on the Suffolk County Land and Tax Map as Section 106, Block 5, Lots 26.5. According to the town zoning map, the property is located in the light industrial district and the neighborhood business district. The signs today that are being proposed are part of a larger project which involves a renovation and expansion of a commercial restaurant building on the premises, which is to be operated by the Chaz Smithtown LLC and to be called the Chaz American Grill, or excuse me, the Chaz American Restaurant. The renovated facility will accommodate, as I said, a restaurant, and as it did before, the seating will remain generally the same. Notably, on February 3rd, 2025, the town's planning department granted site plan exemption for this project as well. As the gentleman mentioned earlier, we're requesting 4 variances, both from Section 322-69A and 322-69CT. Excuse me, C1. I can introduce Andy Beckerman if you have any questions for him regarding the technical aspects of the sign. Otherwise, I can go right into the 5 factors and our explanation as to why we see that this board should grant them. Does anybody have any questions for Andy?
Anyone have any questions? They're basically what's on our, on the application, and
Correct.
all 3 are illuminated?
Andy, all 3, right? Yeah.
All three signs are illuminated.
Actually, can we just have you, have him come up and just say his name and his address for the record?
Good evening. My name is Andrew Beckerman, Display Makers, 80 Lake Avenue South, Nesconset.
Thank you.
And yes, in answer to your question, all the signs are illuminated signs. Yes,
Internally illuminated.
internally illuminated, correct.
Thank you.
Thank you.
Okay, so beginning with whether the requested variances will create an undesirable change in the neighborhood or a detriment to the nearby properties. As previously mentioned, the property is located in the LI district as well as the NB district along a main commercial thoroughfare, and the proposed signs will be very similar to other signs in the area, so we don't believe that this will cause any detriment to the surrounding community. Additionally, the proposed signs are simple, attractive in design, and suited to address the specific purpose of alerting customers and pedestrians that are walking along the street or driving to the restaurant's location. The benefit of being easily recognized by patrons and visitors attempted to locate the restaurant cannot be achieved by any method feasible for the applicant to pursue other than obtaining variances. Even if a patron or visitor is using a navigation system to locate the site, traffic on the Nesconset Highway moves at high speeds, as you all know, so noticeable signs are necessary to alert and attract them to the building's location. This is especially important at night when the building and the area becomes further darker. In addition, the installation of the proposed signs will result in reduced congestion in the area, as less patrons and visitors will hold up traffic by making U-turns and resulting in passing of the restaurant. When considered in conjunction with the size of the building, the size of the property, and the variances that are being requested, we do not believe that they're substantial. The building is over 8,000 square feet, and the differences in height, size, and number of signs proposed will be proportionate and appropriate to the building. Substantiality must be viewed from the totality of the circumstances, which weigh in favor of granting the variances because all three signs, will not have any physical or environmental impacts on the surrounding community. Again, the property is located in one of the busiest commercial corridors in Suffolk County, and accordingly, there are numerous signs of similar size and scale throughout the area. If approved, the applicant plans to install and maintain the signs in accordance with the town's regulations to ensure protection of the environment and the surrounding community. And then finally, while the board may view the alleged difficulty as being self-created, we ask that you not make that dispositive of your decision, in that the variances that are being granted the benefits significantly outweigh the detriments to the surrounding community and the neighborhood.
Thank you.
And again, I can field any questions that the board may have regarding the signage or for me.
Okay, anyone have any questions?
No, thank you.
Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
We have a motion and a second. All in favor?
Aye.
Case closed. Thank you.
Thank you very much.
The next case is case 19437, GPG 410 Lake LLC. The location is 410 Lake Avenue in St. James, located on the west side of Lake Avenue, 111 feet north of 4th Street. Property is split zone CB and R10. The request is a variance to permit a wall sign to project above the wall to which it is attached for a proposed 44 square foot wall sign.
Yeah, good evening. My name is James Vincent Galliano, 410 Lake Avenue, St. James.
Can you just spell your last name, please?
Galliano.
And you're a member of the LLC?
Yes.
Thank you.
Thank you for the opportunity to speak tonight. I'm here to request relief to install a wall sign on my building at 410 Lake Avenue for Galliano Wine Bar and Restaurant. When we purchased the property, our goal was to create a space for the community, a place where people can gather, enjoy great food, wonderful wine, and a warm, welcoming environment. To participate meaningfully in St. James Day this past October, we ordered a sign early so that the building would present well and contribute positively to the event and to the street. At this time, I was not aware that the sign could not project above the wall of the building. I want to clarify a few important points. The sign will not affect any neighboring properties as it is fully attached to the front wall of the building. We did not install the sign. Instead, we chose to follow the proper process and bring this request before the board. The request is not substantial. The projection above the roof line is minimal and does not encroach on any setbacks. Because the sign was already ordered and fabricated months ago, the only alternative would be to purchase a completely new sign. There is no impact to the environment, no ground disturbance is involved, no equipment outside of the building, and no trees or natural barriers are affected. And finally, while this difficulty is technically self-created, it came from the enthusiasm to prepare the building for the community and to get a head start on improvements, not from attempting to circumvent any regulations. Our intention with this project is to enhance Lake Avenue and contribute positively to ongoing revitalizations of St. James. We want the building and eventually the business to be something the community could be really proud of. Thank you for your time and consideration. I am happy to answer any questions.
Find out if we have any. Anyone have any questions?
Yeah, the sign, I'm assuming the back is solid, where the light is not gonna shine back
behind the building.
So it's actually not an illuminated sign.
It's not illuminated.
No, it is not illuminated, and that rendering is slightly off. It's actually going to protrude further down than it is showing further up.
And it's not illuminated.
No, it is not illuminated.
Thank you. Anyone else?
You plan on keeping the awning there?
Yes.
Okay.
Yeah, so it would have to protrude out further and drop
Right.
down below.
Sabrina?
No, thank you.
Anyone in the audience have any questions or concerns on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion is second, all in favor?
Aye.
Case closed, thank you.
Thank you.
The next case is case 19438, Anthony Gomez. The location is 11 Nob Hill Drive in Smithtown, located on the north side of Nob Hill Drive, corner of Nob Hill Drive, in Smithtown. The property is zoned R21. The request is a variance to reduce minimum front yard setback from 50 feet to 32 feet for a proposed 444 square foot attached garage addition, and 50 feet to 47 feet for a proposed 419 square foot front porch. Reduce minimum side yard setback from 16 feet to 13 feet for proposed 444 square foot attached garage addition. Proposed 546 square foot first floor addition, and proposed 620 square foot second story addition.
Good afternoon. My name is Anthony Gomes, 11 Nob Hill Drive, Smithtown, New York, 11787. John will be presenting the...
Good evening, Board. My name is John Gleason, architect for the project at 336 6th Avenue, St. James, New York, 11780. Anthony Gomes is planning to build out a generous-sized addition that is proposed for the west side of his existing house. It will include 2 bedrooms, family room on the first floor, a 1.5 car garage, along with a large porch that spans the entire width of the front of the house. As far as the 5 criteria, the addition will not interfere with any neighboring properties. The rear wall of the addition faces the back property line, and the neighboring home that is along that back property line has a garage located adjacent to the setback for the relief we are seeking. So there's not like living space or anything directly on the other side of the fence line. The proposal is not substantial because if you review the other homes on the street and in the neighborhood, the Gomes residence is currently the smallest in size, and the addition will match other sizes of homes in the neighborhood. So it's going to be a great enhancement for this house and the neighborhood. Benefit cannot be achieved by another means due to the fact that the existing garage is on the same side of the house as the kitchen. This is the most logical place for this addition, on the left side of the house, because that's the way the house now circulates. The kitchen, entryway, everything would have to be flip-flopped, and to put the addition on the right-hand side, it just would be not feasible. There will be no environmental hazards or any trees being taken down to affect this addition. The addition is not built yet. It's in the process of being permitted. We received a note from Department of Environmental Waterways that we will be installing an upgraded septic system due to the increase of bedrooms. That's what they're going to ask us to do, which we'll comply with. I submitted to the chairman a letter and list of signatures from 7 neighbors giving support for this addition and proposal. And if you have any more questions, I'd be happy to try to answer them.
Okay. Anyone on the board have any questions?
No, thank you.
No? Matt?
The only thing I'll point out, the front yard setback, it's kind of like a odd situation where, if you go back to the survey, Matt, it was part of a temporary turnaround from that subdivision, meaning that eventually the road would be extended and the turnaround would be removed. Normally, you kind of eliminate that right-of-way area and extend the front yard all the way, or, 10 feet back from the road. They didn't do that back then. I believe it's probably because there might be drainage or something under there, so whether you do an easement or you leave it a right-of-way, but it is set back from the road much further than it appears on that survey.
Okay, thank you. Sabrina?
Yes, Mr. Chairman, as Mr. Gleason has stated, it will need Department of Health because of the addition of another bedroom. So as soon as you submit your application, please forward to our department.
Will do, yes, absolutely. The planning department makes a great point that was abandoned cul-de-sac, and you can see the darkened line on the curve along Nob Hill Drive, provides for a large front yard. So the setback numbers kind of, it's legally, that's the numbers they are, but in reality, it's a large front yard because of the town right-of-way there that was abandoned when they filled in the cul-de-sac.
Thank you.
Okay, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion and a second, all in favor?
Aye.
Our case closed, thank you.
The next case, case 19439, Patrick and Amy Oberlees. Location is 220 Jefferson Avenue in St. James. It's on the southwest corner of Woodlawn Avenue and Jefferson Avenue. Property is zoned R10. The request is a variance to reduce the minimum front yard setback from 40 feet to 29 feet for an existing 112 square foot shed.
Hi, good evening. My name is Patrick Oberlees, that's Oberlies, and I am the owner and reside at 220 Jefferson Avenue in St. James. I'm here to speak on my application for a setback variance on the Woodlawn Avenue side of my property to maintain an existing 112 square foot shed. I'm requesting, as we stated, the relaxation from 40 feet to 29 feet on the setback. The shed was placed in the same general location as my previous shed, which had been on the property for several years. The new shed has a slightly larger footprint in order to meet my family's storage needs. It occupies essentially the same area and serves as a replacement for the old deteriorating structure. Due to this increased footprint, it's caused the existing shed to slightly encroach into my side yard or the required front yard. The location of the shed was chosen out of necessity. Moving it further and completely into the required rear yard here would have required established trees to be removed, regrading, and possibly significant masonry work due to my existing paved patio. These changes would create substantial personal expenses to me and my family and would alter my existing landscape. The combination of the trees and the patio limits the usable square footage of my rear yard, making the shed's current placement the only practical and reasonable location. Importantly, the shed exceeds the required setbacks from my rear neighbor's property lines. It creates no line of sight issues for traffic on Woodlawn Avenue or any other roadways. And I believe the shed, blends in well with the surroundings and presents a clear improvement from the old structure to a more attractive and well-maintained one. My intention was never to create any negative impacts on a neighbor or the neighborhood. I believe this variance will allow me to maintain a structure that is functional for my family, visually unobtrusive, and beneficial to the overall appearance of my property. Thank you for your time, and I'll ask any questions that you might have.
Thank you. Anyone on the board have any questions?
No, thank you.
For the record, we did receive a letter in opposition. We're just going to make part of the record. Planning, you have anything?
No, thank you.
Sabrina? Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion is second. All in favor?
Aye.
Case closed. Thank you.
The next case is case 19440, Dylan Kolarsik. I believe that's how you say it. Location is 220 Riviera Drive in Kings Park, the south side of Riviera Drive, 269 feet west of Walnut Road. The property is zoned R10. The request is a variance to reduce the minimum rear yard setback from 35 feet to 4 feet for an existing 145 square foot first floor addition, existing 142 square foot second story front porch, and existing 169 square foot front deck.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tramarko. I represent the applicant. We've submitted the affidavits of posting and mailing to Matt Mazzaros. If you just take a quick look at the survey, as the board is well aware, this is in San Remo. Actually, the prettiest part of San Remo, I should say, on Riviera Drive. And it's quite a large piece of property, considering what I usually, and most people come in on for variances for the San Remo lots. In any event, you can look, if you look at the survey, the existing one-story frame dwelling, and there's a couple of decks, and there's an entranceway. This was all granted many, many years ago, and for some strange, by the way, I should say, before I get into that, there was another house on the property. They were granted 2 houses on this piece. And I guess it's really, you know, almost an estate in San Remo. But in any event, the prior owner added an addition and the upper and lower decks. The history of the property is that years ago, as I said, there were 2 houses on the property. One house actually burned down. The owner received an approval from the BZA to build another second dwelling on the property. The prior owner also applied for relief, for the relief sought that we're asking for today. And and that was approved. From our research, it shows that they just never got a CO. That's not my client, that's the client, the owner before him. So although when you look at it, and it's very close to the property line, this was done many, many years ago, and apparently approved by the town. So we don't think that the variance will produce an adverse effect on adjacent properties. As the board knows, on Riviera Drive, the properties start to go up in the back. So the people on the road behind Riviera, which I can't remember the name of it now, is probably 20, 30 feet higher, at least that, from the road from Riviera Drive. So we don't believe it'll have an effect on adjacent properties. Again, it's kind of an estate in San Remo, this piece of property. And again, it was previously approved by the board. The other thing is that we don't think it's substantial. Even though it looks really substantial, this was done many, many years ago, and it was approved. So we're just asking the board to legalize again for the second time its approval of the variances requested. Can we achieve the benefit by an alternative? Well, the only benefit would really be is, and it wouldn't benefit us, that's for sure, is we'd have to knock everything down and build a new house there, which we're not able to do. If you look at the pictures of the house as it exists, looking at the survey really doesn't do it justice, but if you look at those pictures, it's a very pretty house, set all the way back. The garage is under, and from an aesthetic point of view, it certainly fits in the character of the area. Whether the variance would have an adverse effect on the environment, the house, the property, it's been there for a number of years, and so there really isn't any environmental issues that I could think about and come up with. Whether the difficulty was created by the applicant or the former owner. Well, the applicant did buy the property from a former owner, but I think he believed that everything was in place because of the issue of the approvals by the board already. So we asked the board for its favorable consideration, and if the board has any questions, I'd be happy to answer them if I can.
Find out. Anyone on the board have any questions?
No, thank you. No.
Planning.
Just a few comments. Like Vinnie said, there was 2 houses on this property at one time. I was just looking through the history. There were a lot of much more substantial variances granted on this property in the past. What they're asking now is pretty modest compared to the past. And just a lot of people ask about the high groundwater situation. The addition is not in the high groundwater area. It's toward, the high groundwater's found towards the front of the property, not the rear. So they are avoiding that, just for the record.
Thank you. Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Motion and second, all in favor?
Aye.
All right, case closed. Thank you.
We don't have notices for this one, right? So this one, we do need the affidavits. This is case 19441, Drew Besserman. Location is 71 Cornell Drive in Smithtown, north side of Cornell Drive, 98 feet east of Amherst Lane. Property is owned R10. The request is a variance to reduce the minimum rear yard setback from 50 feet to 38 feet for a proposed 464 square foot, 1-story rear addition.
Hi, good evening. Christina Bravin, Morano Expediting, P.O. Box 39, Bethpage, New York. Okay, the proposal is to construct a 464 square foot, 1-story rear addition. The existing home contains the kitchen, dining, and living areas in a single combined space, which is undersized for the 3 uses within the current footprint. The proposed addition will allow the owners to create a dedicated kitchen area while combining the dining and living room into a more functional, spacious layout. The lot is slightly irregular, with the northerly property line angling in as you go into the rear yard. As a result, a portion of the addition encroaches into the rear setback, and at its closest point, the addition will maintain a rear yard of 38 feet 4 inches, gradually increasing to approximately 42 feet at the northeast corner. We do not believe the variance requested will have any negative impact on the surrounding properties, nor on the environment. As you see from the photos we submitted, there aren't any trees to be removed or grading to happen. The rear of the subject parcel abuts 2 separate lots, 1 residential property whose home will remain approximately 60 feet from the proposed addition, and 1 town-owned recharge basin sump. The project fully conforms to all side yard setback requirements. We also do not feel the variance request is substantial. The owners have very limited rear yard space available for expansion, and a reasonable portion of the proposed addition will continue to maintain compliance with the required setback. And there are no feasible alternative locations or designs that would eliminate the need for this variance. Attempting to design an addition strictly within the required setback would result in an irregularly shaped extension that would not provide adequate functional space to meet the needs of the family. And they have spoken with the neighbors on the most affected, and no one expressed any objections or concerns.
Thank you. Anyone on the board have any questions?
No, thank you.
Planning?
No, thank you.
Sabrina? Okay. Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Motion is second, all in favor?
Aye.
Case closed.
Thank you. Happy holidays.
You too.
The next case is case 19442, Live on the Porch LLC. Location is 602 Smithtown Bypass in Smithtown. It's on the northwest corner of Smithtown Bypass and Mount Pleasant Road. Property zoned NB. The request is a variance to increase the max height of a wall sign from 15 feet to 23 feet for a proposed 90 square foot wall sign. Increase the max height of a sign from 15 feet to 17 feet for a proposed 48.75 square foot wall sign. Increase the number of wall signs from a max of 1 sign to 2 signs. Permit a wall sign not to face a public street. Increase the max area of a ground sign from 32 square feet to 40 square feet for a proposed 40 square foot ground sign.
My name is Robert Brennan, last name B like boy, R-E-N-N-A-N. 1328 Motor Parkway, Atlantia, New York, 11749.
Okay, Mr. Brennan, are you a member of the LLC?
I am.
Okay, thank you.
I'm here on behalf of ownership and the tenant.
Okay.
What we have, this building was previously a dry retail building. It was most recently a hot tub showroom, which has since relocated to the building next door. We've obtained planning approval for a change of use to commercial entertainment here. Tenant is seeking these variances for signage, some of which are just due to the nature of the construction of the building. The one that is in the front of the building with the increase in maximum height from 15 feet to 23 feet. As you can see, to center the sign on the building, we have to put it that high. We have an awning that's planned over the front door. So that's really the only place that we're going to be able to put it to center it on the building. Bringing it lower would just make it not feasible with the transom windows. We have another request for increasing the square feet of the pylon sign, an additional 8 square feet from 32 to 40 square feet to increase the visibility from 347. And finally, the request for a second sign, which also has an increase of height from 15 to 17 feet. Along the same lines, the construction of the building wouldn't allow us to put it any lower. You don't have this, but we brought this along with this. We are requesting the second sign. This is a view of the building from the intersection at Mount Pleasant Road and 347 looking westbound, which is where you would see the sign that you have up now that says Live on the Porch. Since, over the years there's trees on the corner of the property, and since we redid, when Friendly's was converted to Starbucks, we had a landscape plan. We had to plant additional trees. Those trees are maturing and now blocking the view of Live on the Porch building from 347, which is really the best angle for traffic to be able to see this building. So for a new venture, for a spot for Smithtown for people to go to in this new business, and we're all very excited for Mike Del Giudice to be here. We're trying to maximize his exposure and get the most visibility possible.
Thank you. Anyone on the board have any questions? No? Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
We need a second. Motion and a second. All in favor?
Aye.
Thank you very
Motion
much.
carries. Case closed. That's okay.
So I have to put the... Okay. Yeah. The next case is case 19443, Ernest Wong. Location is 1 Tammy Court in Kings Park. It's on the southwest corner of Tammy Court and Bear Lane. The property is owned R21. The request is a special exception to permit temporary living quarters for a family member.
Good evening.
Good evening, Mr. Chairman and members of the board. My name is Ernest Wong, spelled W-O-N-G. We have been the homeowners at 1 Tammy Court in Kings Park for the past 30 years. We are requesting an approval to build a first floor extension to accommodate my aging in-laws who are in their late 80s and have ongoing health issues. Our goal is to provide a safe, comfortable living space for them so they can remain close to family and avoid the risks associated with stairs or living alone. The proposed extension will be approximately 650 square feet and will include a small living room, 1 bedroom, 1 bathroom, and a small kitchenette. The primary access will be through the main house with an additional sliding door to serve as an egress. On December 5th, we received an email from the Department of Environment and Waterways informing us that we are required to submit an application to the Office of Wastewater Management. However, we have not received a certified letter in the mail yet. We will fully comply with that process. Now, since this is a special exception process, do I need to go through the 5?
The town already did that for you.
Okay.
You want to go through it?
Yeah, sure. So,
Make it easy on you.
Thank you.
So, everything was complied with on the general criteria. The specific ones, you mentioned it's for your parents, correct?
My in-laws, yes.
You don't exceed 4% the lot area, which that's a requirement. It's got to be 600 square feet or 4% of the lot area up to 1,000 square feet. So you complied with that. It looks like it's economical to convert it back to a single-family residence.
Correct.
And the last one basically just says, you know, it's good for a 3-year period, has to be renewable every 3 years by the building department. And it terminates upon, you know, you selling the house and moving. So that's, you comply with it, but you have to comply with it anyway. So we do recommend approval.
Thank you.
And this is one of those cases, it's a special exception that you do meet all the criteria, so this board must approve it. However, we can't take action on it until we get a secret, so the sooner you can apply to Department of Health, correct?
If you submit your application, you'll also receive an actual receipt from the Department of Health. You can forward that to our department so we can continue the review.
Excellent.
Matt, do you have anything else?
That was it.
All right. Anyone on the board have any questions? No? And would anybody in the audience like to be heard on this one? Being none, I'll entertain a motion to close the hearing.
So moved.
Motion and a second, all in favor?
Aye.
All right, case closed. Thank you.
Thank you for your time.
The next case is case 19444, David Fletcher. Location 139 South Plaisted Avenue in Hauppauge. It's on the east side of South Plaisted Avenue, 514 feet south of Stanley Place. Property is owned R10. The request is a variance to reduce the minimum side yard setback from 12 feet to 10 feet, reduce total side yards from 28 feet to 25 feet for an existing 597 square foot rear deck, reduce minimum rear yard setback from 50 feet to 44 feet for an existing 329 square foot screen porch addition, reduce minimum distance from any lot line in the rear yard from 6 feet to 3 feet for an existing 146 square foot shed.
Those are from your neighbors? You can just turn those into us.
Good evening. My name is David Fletcher. I live at 139 South Plaisted Avenue with my wife. I'm a retired music educator, and my wife was a retired middle school principal in Hauppauge. I've lived here this is my entire life. This is my parents' house. I built the sunroom not realizing I needed permits, and I just like to take care of whatever I need to take care of now. It enhances my house, our living space. I haven't had any issues with my neighbors with what we've done. I think it makes my house look really, really good in the back, and we've used it a lot.
Thank you. Anyone on the board like to be heard on this application?
No, thank you.
No? Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this one? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion is second. All in favor?
Aye.
Case closed. Thank you.
Next case is case 19445, Thomas and Jacqueline Bonato. Location is 15 Dolores Lane in Fort Salonga. It's on the southeast terminus of Dolores Lane, 913 feet south of Sunken Meadow Road in Fort Salonga. The property is zoned R43. The request is a variance to increase the max permitted paved surface in the front yard from 25% to 27%, and side yard from 25% to 38% for a proposed driveway.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tramarco. I represent the applicant. I've submitted the affidavits of posting and mailing to Mr. Mazzaros. As you can see, this is a very minor application, and we want to go from 25% to 27%, and side yard from 25 to 38%. Again, this is a large property in Fort Salonga. The home is currently being built, and as you can see from the survey, that it's at the end of a cul-de-sac. So it's really very discreet, the maximum extension that we're asking for. And it's not going to affect any surrounding neighbors. Would it produce an impact on adjacent properties? There's a full acre of property in the driveway, which is a little bit extended, as you can see from the percentages that we're asking for, is at least 50 feet away from a neighbor's house. Again, we're building the house now. Certainly, we haven't put in any driveways, so that anybody on that driveway, for example, my client driving his car back there or whatever, is not going to be, it's not going to be seen by any other homeowners, whether the variance is substantial. Obviously, you can see that both side and front yard variances are not substantial, as you can see from some of the other times we've come in here and people have paved half their front yard and so forth. Whether the benefit can be achieved by an alternative, no, I guess we could not ask for variances, but that would just make it a little more difficult for my clients to move in and out with their cars and so forth. And finally, well, fourthly, is an environmental issue. I don't think so. It's a paved driveway, basically, that's just a little more than what the town allows. And was the difficulty self-created? Obviously, we haven't gotten to that stage yet. I believe the foundations were poured, and I think we're at the framing stage. So we ask the board for its favorable consideration.
Anyone on the board have any questions on this application?
No, thank you.
No, thank you.
Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this one? Being none, I'll entertain a motion to close the hearing.
So moved.
Motion is second. All in favor?
Aye.
Case closed. Thank you.
The next case is case 19446, Glacier Point Enterprises. Location is 380 Oser Avenue in Hopog. It's on the north side of Oser Avenue, 982 feet east of Parkway Drive South. Property is owned LI. The request is a variance to increase the max height of a wall sign from 15 feet to 48 feet for a proposed 206 square foot illuminated wall sign.
This is the last one, I promise. Good evening, Mr. Chairman, members of the board. Vincent Tremarco, 1040 West Jericho Turnpike, Smithtown, New York. Well, you heard a bunch of applications for sign variances, but none as high as the one I'm requesting. But I think the board should really look at the fact that the town allowed a 48-foot-high building in, it's in the industrial park, obviously. Now, why does Glacier Point need a sign so high? Well, number one, I think aesthetically it would look pretty silly if it was down much further on the building. And what does Glacier Point do? Just for informational purposes, it's an ice cream, ice pop, confectionery distributor. Not only do they deliver, but I am told they have people coming in and picking up various frozen desserts for sale, either at stores or on ice cream trucks and what have you. So one of the reasons why they want the sign to be where it is because the drivers who come in and out will know where the place is. Since it's in the industrial park and since the board, not this board, but the town board has allowed certain properties, this one being on Oser Avenue, to build these buildings so high, it seems like an anomaly to then say, well, you know, you can only put up a 15-foot-high sign, which obviously, you know, the board has varied many times. Obviously, I don't think anywhere to 48. Maybe this is the first one, but again, the town permitted us to build that building. And if you look at it without a sign, it looks like one giant wall, more like a prison, I think, than anything. And this would kind of break up the aesthetics of the look of the building. So the first question really would be, would it have an impact on adjacent properties? I don't think so, because it's an industrial area and it fits in with the characteristics of the area with the new higher building allowances. So maybe what the town has to do is think about a different sign ordinance for different areas of the town. Whether the variance is substantial. Yeah, if you look at the 15-foot ordinance and what we're coming in for, it's, my math, I think it's triple and a little bit more than what the town allows. So many times we're coming in here for variances which really don't make sense based upon the allowance of the height of the building. Whether the benefit can be achieved by an alternative, yeah, I guess we could lower the sign on the building, but again, look at that picture. And how much benefit would it be to lower it, I don't know, say even 5 feet? Maybe that's something that the board wants to think about, but, you know, again, we were allowed to build this building. So maybe the town has to look at what the ordinance should be in different areas of the town. Can it be achieved by an alternative? Sure, we could lower it. Does that benefit anybody? Who does it benefit? There are other buildings, you might say, well, it'll establish a precedent. But again, if they're allowed to build a building that's 48 feet high, and then you say, well, we're going to only give you a variance to 35 feet, you know, that's a big reduction, and I don't know that it makes any sense. Let's see, what else? Whether the variance would have an adverse effect on the environment. Well, I guess there's environmental impacts, site impacts and so forth, and the town of Huntington has certain requirements about that, but I don't see any in the town of Smithtown. The building is there. It's not like we're saying we want to build a building and so forth. So we don't think it'd have an adverse effect on the environment. Whether the difficulty was created by the applicant. I'm going to say this, and I don't know if the board will agree, but I think the difficulty was created by the town, and not in a bad way. The town allowed this building to be built, and it's a good thing because it's in the industrial park on Osser Avenue, which everybody knows where it is. So what or who is it affecting? It's certainly not affecting residents who might see a sign like that. It's only going to affect other businesses in the area, and I think the other businesses in the area could care less. We haven't built the sign, obviously, and we're seeking your approval. I guess that's it. I don't know if the board has any questions.
Well, I will respectfully disagree with you because I believe it was this board that gave you approval to build this building, because I think it lands right in the middle of the overlay district. Is that correct?
The overlay district splits the
So
middle.
the benefit to your applicant and detriment is that half of his property is in the overlay district and half of it is not in the overlay
Well,
district.
that's what I thought, so you granted,
So we granted the variance to 48 feet. However, I personally agree with you that I think that the height isn't as impacting as long as it's in the overlay district side, which
So I'm not
it
gonna
currently is not.
so I'm not going to argue with you. Okay, thank you.
I'm only one person, but
I know.
I would personally, if any relief was granted, would say that if we're going to grant that relief, that it should be in the overlay district side, and that, I believe, is the eastern side of the facade. Just my 2 cents.
Thank you.
Anyone on the board have any questions? No? Planning?
Yeah, sorry, I thought Adrian had something. So, yeah, just to kind of piggyback off of what you said, I do agree it should be on the overlay side. I did drive up and down Oster Avenue. I didn't see any signs this height. So I didn't see any, probably even like 30 feet. So I do believe it would be an undesirable change. There definitely is an alternative in moving it to the overlay side or lowering it. We did measure on the screen there, you could see where the blue starts. It's about 37 feet. So I don't know if you could lower it underneath that. You know, that is an alternative to bring it down. Maybe you shrink the size of the sign so it's not as impacting. Like you said, it's at least 3 times higher than what's permitted. So it is substantial. The impact on the environment, it is illuminated, so you're putting it 48 feet high. You could see it from pretty far away at nighttime. And it is self-created. And one other thing to consider is this board at the last hearing, there was an application across the street to increase the height of the building to 42 feet. I believe it was also split in the overlay, so they'll probably look for something similar to what you grant on this application.
Chairman, could I just answer that now, or do I wait?
No, you can answer.
Okay. A question I have for Matt, did you see any other 48-foot high buildings?
There's a building, if you go to the aerial, there's a couple lots to the east. It's like a red brick building. It's that large one. It's 3 lots over. It's pretty tall. There's no wall sign at all.
pretty tall doesn't give me an amount.
I'd
but-
say it's roughly the same height as your
And you
client's
used
building.
a measurement of some sort?
I didn't go
laser?
out there.
Okay,
but
all right,
It's,
that-
it's a tall, it's a tall building. There was no wall sign at all. I didn't see any variance, applications related to wall signs on the property.
Okay, that was the only question I had from that. Thank you.
Is that it, Matt?
Yeah.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion is second. All in favor?
Aye.
Case closed. Thank you.
Thank you, Mr. Chairman.
Next case is case 19447, Michael Barini. Location is 12 Alfred Lane in Kings Park. It's the west side of Alfred Lane, 93 feet south of Melody Lane. Property is owned R21. The request is a variance to reduce the minimum rear yard setback from 75 feet to 73 feet for a proposed 77.73 square foot first floor addition.
Good evening, Mr. Chairman, members of the board. My name is Mel Gonzalez, MIG Architect, PLLC, office at 200 Corporate Plaza, Suite A102, Orlando, New York, 11749. I'm here with the homeowner,
Can we
Michael
just have
Barini.
them first? If you could just give us your name and address for the,
Michael Barini, owner of 12 Alfred Lane, Kings Park, New York.
and we'd like this gentleman to speak on your behalf.
Yes, please.
Thank you.
Thanks, Mike. So, as stated, we are renovating the home and doing a very, very modest addition. And the addition is 77.73 square feet. It's de minimis. And the way the property is situated is such that the building envelope does not allow us to put the addition elsewhere. It is actually a mudroom, laundry room addition, which is adjacent to the garage and accessible or adjacent to the kitchen area. It's impractical to put it anywhere else. As far as the detriment to the neighborhood, we don't see that as being any detriment to the neighborhood since it's so small and fairly screened. As far as trying to locate it elsewhere, as stated, it's just not practical. Whether the variance will have, any other effect on the neighborhood, I don't think it will. And whether the action is actually self-created, it is, but as stated, it is in keeping with the neighborhood, also the home. And I also want to state that there was a larger variance granted, I believe, in 1980. The backyard setback that was granted was 49.2 feet. So this, in comparison, is very, very minute. Any questions?
We'll find out. Anyone have any questions? Planning?
No thanks.
Sabrina?
No, thank you.
Anyone in the audience have any questions? No? All right. I'll entertain a motion to close the hearing.
So moved.
Motion is second. All in favor?
Aye.
Case closed. Thank you.
Thank you very much. Have a great
You.
holiday.
You too.
The next case is case 19448, Zwanger Pasiri Radiology. The location is 99 Smithtown Bypass in Hopog. It's at the intersection of the Smithtown Bypass and Town Line Road. Property is zoned NB. The request is a variance to increase the max height of a wall sign from 15 feet to 34 feet for a proposed 158.33 square foot wall sign. Sign A. Increase the max height of a wall sign from 15 feet to 32 feet for a proposed 78.33 square foot wall sign. That's sign B. Increase the number of wall signs from a max of 1 sign to 2 signs on sign B.
Hi, my name is John Prahalis. It's Prahalis, JM Signs. As he had spoken, we are seeking a variance for the front sign, which we want to raise and make it larger only because it's a 40-foot building, and to go with the 15 feet and the sign requirement, the sign would look like that. So if you want to look at it, I just made a,
Excuse me, do you have a few things for the notices? We have your affidavit of mailing. Do you have the receipts? And do you also have the affidavit of posting? It also says you sent out the mailing September 12th. That was 3 months ago.
That's the mailings. Okay, so this is,
Are we good? No.
Is this acceptable? It's a copy.
Thanks, John.
I don't believe they can legally hear this. Yeah, you could adjourn it to the next meeting.
January?
But, so you'll have to repost the property, fill this out. I don't believe you have to do mailings again, right? So you're gonna wanna come to our office, pick up signs again with the next date that you have it for, and then you'll have to bring that affidavit of posting, notarized, filled out completely.
the one I had was,
So this is just the mailing. There's two forms. You sent out mailings and you had to post a sign on the property.
we did that.
Right, but you have to fill out an affidavit swearing you did it, and it's not filled out. It's gotta be notarized, so. Yeah, you gotta bring it to the meeting. Sorry.
I take that,
You should take it back, yes. And then
Submit it whenever the
So we're
hearing
gonna
is.
adjourn this. He needs to bring back the affidavit of posting?
Posting. You gotta repost the property.
Okay.
So come into the planning department, grab signs. You probably need 2 of them. Right, and then, whatever date you do next.
So you're familiar with the procedure where you have to post it 5 days before?
yeah, that
And then just have that that affidavit of posting notarized the day of the hearing, and then you bring it in. You've already got the affidavit of mailing?
Correct, yeah.
Okay, so, first meeting in January 13th?
Yep.
So, we'll hear it on the 13th. No need to re-mail, just repost and then come in. Just grab the mic. Yes.
Yes,
Mayor.
for the posting, you have to notarize it the day of the hearing.
It's basically an affidavit that says that you posted the property for the previous 5 days. All right, and we will see you on January 13th. That's okay, thank you. I believe that's it for our open cases, the new cases. On to the decisions. Case number 19435, Brett Little.
Oh, what started from the beginning?
Right
Gee
back
whiz.
to the beginning.
Oh, come on. Okay. On case 19435, I'll make a motion to approve this application as presented.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
All right. It's approved, 5-0. Case 19436, the Chaz Smithtown LLC.
On case 19436, I'll make a motion to approve the application as presented.
Second.
Motion and a second. All in favor?
Aye.
All right, motion carries 5-0. 19437, GPG 410 Lake LLC.
On case 19437, I'll make a motion to approve the application as presented.
Second.
Motion and a second. All in favor?
Aye.
All right, motion carries 5-0. Case 19438, Anthony Gomes. I believe we're waiting on a secra, so no action. All right, case 19439, Patrick and Amy Oberlees.
On case 19439, I'll make a motion to approve the application as presented.
Second.
Motion and a second. All in favor?
Aye.
All right. Case 19440, Dylan Kolarchik.
On case 19440, I'll make a motion to approve the application as presented.
Second.
One quick thing. It's type 2 LWRP NA. There's no,
Not needed, right?
not needed, right? Okay. Sorry, we have a motion and a second. All in favor?
Aye.
Motion carries. 5-0. Case 19441, Drew Besserman.
On case
We have comments.
Yes,
Yes.
for the record, our seeker is based on our understanding that there are no additional bedrooms being added to the existing three-bedroom, single-family dwelling. Otherwise, an increase in the number of bedrooms may require Health Department approval.
Okay, thank you.
Okay.
On the merits,
On case 19441, I'll make a motion to approve the application as presented.
Second.
okay. Motion and second. All in favor?
Aye.
All right, motion carries 5-0. Case 19442, Live on the Porch LLC.
On case 19442, I'll make a motion to approve the application as presented.
Second.
Motion and second. All in favor?
Aye.
All right, motion carries 5-0. Case 19443, Ernest Wong, another one that we're waiting on secra, so no action. Case 19444, David Fletcher.
On case 19444, I'll make a motion to approve the application as presented.
Second.
Motion and second. All in favor?
Aye.
All right, motion carries. Case 19445, Thomas and Jacqueline Bonaiuto.
On case 19445, I'll make a motion to approve the application as presented.
Second.
Motion and second. All in favor?
Aye.
All right, motion carries 5-0. Okay, case 19446, Glacier Point Enterprises. You guys want to discuss this one a little bit?
You want to decide, are you going to lower it or just,
Well, I guess that's what we talk about, because
Yeah.
obviously whatever we do has,
I like the overlay, like you were talking about, that aspect, but if they drop it into the white instead of the blue,
okay,
and it's blue letters, they'll stand out.
yeah. I believe the blue is on the,
Top line.
The non-overlay side, yeah.
on the non-overlay side.
Yeah,
it
so the
would
west
be-
side, so you're looking
so
at
if
the
you look
building?
building, you see the gray, same concept, but basically where the blue is, a little bit to the left of that is the line where the overlay district is now
So if they drop the sign down into the white section, below
on the
the
right.
blue.
Everything to the left is not overlay, everything to the right is overlay.
Yeah, but then it'll be on the left side, the blue side.
Correct. So I guess the point we were trying to make was that the overlay is from the blue line to the right. That if the town board had the foresight to make that overlay district where you can go taller because the residences are to the left. Not close,
All
but
right, I got you, and so the gray is the overlay side.
correct. So any relief that we may grant, I would say, should be predicated on that it's further away from the residences in the overlay side. And there are very few properties where it's split like this.
Yeah, I mean, I think it's measured like 1,000 feet from the residence, so it probably splits most, I don't think it follows like perfectly property lines. It probably splits.
Right, but
property.
it's not like everyone in the overlay district is gonna have this, this condition. We may wanna see if the town board would, maybe consider changing the ordinance as it relates to the overlay district with respect to signs.
Right,
Because obviously, as buildings go up, they're gonna be coming here more.
right.
But I guess the question for the board is, A, do we wanna grant relief? And if we do we wanna condition it? And to what level do we wanna grant the relief?
How far down would it go to the white? Is that, you know?
So I didn't measure the right side, so up to the bottom of the blue, that was 37 feet. So I guess if you go, it looks like
35?
it's probably gonna be, yeah, it's a little bit lower where the gray meets, the dark gray meets the light gray, so yeah, you're probably right about 35.
I'm okay with that. I mean, it does give them relief. It doesn't, put it way up.
But now it's not gonna be on the overlay section.
It would be
Cut
in the
off.
overlay district,
It will be.
yeah. So it's further away from the residences.
At 35 feet?
And I think the blue and the gray don't exist the way it was built. I think that's an old drawing.
No, I took a photo. I went out there yesterday or Monday.
So that's okay, so that's painted. That's after the.
That was taken Monday.
The original plan with the application.
Yeah, it was just
Was
gray.
not,
Yeah,
okay.
this was taken Monday afternoon.
Okay.
So that's what they submitted, yeah. Whenever they filed, November 18th, so the pictures were probably taken a couple days before.
So what are you guys thinking? Are you thinking,
So the top of the sign would be
It almost looks like it's
that
dented
gray.
in, like,
yeah,
you know, it's deceiving.
I
at
think,
35 feet, I think that would be.
I think that's fair.
Yeah.
Yeah,
I think it would look good, actually.
okay,
Looks better.
35 feet within the overlay district.
with the condition
Mhm.
that it be within the overlay
Okay.
district. Is everyone okay with that?
Yeah. Yeah. Okay, so let me read it.
Yeah.
On case 19446, variance to increase the maximum height of a wall sign from 15 feet to 35 feet for a proposed 206 square foot illuminated wall sign, with the condition that it is on the overlay side of the building.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
All right. Motion carries 5-0. Partial, I guess, a partial approval.
35 feet.
Yeah. Case 19447, Michael Barini.
On case 19447, I'll make a motion to approve the application as presented.
Second.
Motion and a second. All in favor?
Aye.
Aye.
All right, motion carries 5-0. Case 19448, Zwanger Pasiri is going to be heard on January 13th. Case 19288, 521 Property Management LLC, I believe is adjourned to February, first
Tenth.
meeting in February?
Yep,
10th.
February 10th.
February 10th. Okay, we have some from the back that we can work on. First one is ADT Real Estate, 19242.
I can read
That was heard in February.
Yeah.
No, it was actually heard last meeting. I don't know, I think it was.
Oh, right,
It
we
was
adjourned it,
originally.
we initially heard it, and then it was.
Yeah, so it was last meeting, and Gay cannot vote, or Gay wasn't at the last meeting, so only the other four can vote.
Okay. 19242.
Okay. Okay. On case 19242, you gonna,
I believe we have a PAR on it also.
yeah,
You have the
Yeah, you want to
secret.
read the, hold on, we have to do, secret first, so you want
Right.
to do that?
Yeah, on case 19242, I'll make a motion to approve the unlisted deck.
Second.
We have a motion and a second, all in favor?
Aye.
All right, motion carries 5-0 on the secret.
4-0?
4-0, yes,
4-0.
because Gay couldn't, yeah. And now on the merits, we have a planning advisory report.
Request a special exception to permit outdoor storage of motor vehicles in the LI zoning district, approved with conditions. Variance of a special exception standard to increase outdoor storage from 1 times to 5 times the gross floor area, approved with conditions. Variance to permit outdoor storage not on the same lot as the principal use, approved with conditions. Variance to permit a fence gate greater than 4 feet in the required front yard, approved for Pulaski Road only. Variance to reduce the minimum front yard setback on Town Line Road from 50 feet to 0 feet for a proposed 6-foot chain link fence with a gate, deny. Variance to reduce the minimum front yard setback on Pulaski Road from 50 feet to 0 feet for a proposed 6-foot chain link fence, approved to 20 feet only. Variance to alter environmentally sensitive land, steep slopes greater than 15%, approved. Variance to permit construction within 10 feet of slopes greater than 25%, approved. The conditions: 1, this approval is to permit the subject site to be used in connection with the adjacent parcel, that's Suffolk County Tax Map number 23-1-4.2, for outdoor storage of new motor vehicles only, and the applicant shall file covenants and restrictions with the Suffolk County Clerk's Office stating that upon termination of the existing use on Suffolk County Tax Map number 23-1-4.2, the approval shall no longer be valid. 2, the proposed 6-foot chain link fence with gate on Town Line Road shall be installed at the 50-foot front yard setback and at 20 feet on Pulaski Road. 3, a densely planted buffer consisting of Type 2 and Type 3 plantings shall be installed and maintained in both required front yards between the proposed chain link fencing and the front property lines as required by the Board of Site Plan Review. 4, all on-site lighting shall not exceed a height of 18 feet and shall be directed downward and shielded as required by the Board of Site Plan Review.
Okay. Is everyone okay with those approvals and conditions?
Yes.
Yep. All right. Okay, on the merits, we need a motion.
On the merits, on case 9242, I'll make a motion to approve with all the conditions that were read
And partially denied.
and partially denied.
Second.
Okay, motion is second, all in favor?
Aye.
Okay, motion is partially, application is partially approved 4-0 with conditions. All right, next one on the back is Antilla Management, 19420. We heard that one 2 meetings ago, I believe. That's the shopping center over in Hauppauge with Brancinelli's. Okay, I had no problem with the application. This is the one where we were waiting on drainage calculations for the removal of that
Yep.
recharge basin.
So the engineering department reviewed it. They were conceptually okay with it. They will want boring and infiltration tests at the location of the proposed drainage systems at the time of site plan.
Okay, and that's all we needed for the secret, correct? So we need a secret first.
Okay, on case 19420, I'll make a motion to approve the unlisted neg deck.
Second.
Motion is second, all in favor?
Aye.
So
Wait, who was on this one?
So just
So that was
Genadeo,
1021.
Tanzi, Savaretti, Viliante, so
Four.
4.
Okay, so on the secret, it's approved 4-0. And now on the merits.
On the merits, on case 19420, I'll make a motion to approve the application as presented.
Second.
We got a motion and a second, all in favor?
Aye.
Okay, on the merits, approved 4-0. All right, case 19427. The Gap, we have a type 2 Secra.
Case 19427, I'll make a motion to approve the application as presented.
Second.
Motion and a second, and this was on 11/18, so same thing. It is four, it would have to be the four of us. Gay wasn't at that last meeting.
Okay. 4-0.
So, did we, all in favor?
Aye.
Okay, so 4-0. And now, I believe we have Island Air, which we can do also, right? That was heard last meeting, wasn't it?
Yeah.
Yes.
So it'll be the four of us again. And 11/18, 434.
Another PAR, right?
Yep, PAR. So let's do the secret first. 19434 Island Air, secret.
Okay. On case 19434, I'll make a motion to approve the unlisted neg deck.
Second.
Motion and a second, all in favor?
Aye.
All right, secret carries 4-0. And now on the merits, I believe, Matt, you want to read that PAR?
Yep. The request, special exception to permit a modification of a trucking station, approved with conditions. Variance to reduce the minimum side yard setback from 20 feet to 6 feet on the north, that's approved. Variance to reduce the minimum side yard setback from 20 feet to 10 feet on the west, approved. Variance to reduce the minimum parking from 291 to 276 spaces, approved. Variance to reduce the minimum truck loading spaces from 3 to 0, approved. Variance to reduce the minimum parking setback from side property line from 6 feet to 1, approved. Variance to eliminate required landscaped islands, approved. Condition 1, the storage of trucks or material shall not be permitted in the developed and land-banked parking areas.
Okay, everyone okay with the PAR and the conditions? Any questions? All right, you want to make a motion?
Yeah. On case 19434, I'll make a motion to approve the application that was read with the conditions.
Second.
All right, motion and a second, all in favor?
Aye.
Motion carries 4-0. Okay, next one is a request for a one-year extension, 19123, P7 881 Jericho LLC. Everyone okay with a one-year extension on this one?
Sure.
Okay. All right, make a motion.
On case 19123, I'll make a motion to approve a one-year extension.
Second.
Motion and second, all in favor?
Aye.
All right, motion carries 5-0. And case 19368, CP iOS Acquisitions LLC. I believe we had a request to reopen. Is there another letter that was submitted?
Yes, should be in the packet.
It was in here.
Should be the last pages.
Okay. Okay. Did everyone get a chance to look at the letter?
Yeah, I read it.
Okay. Any comments, questions? Still looking? So this property is the one that was down in the industrial park, or not in the industrial, in the industrial area in Kings Park. We heard it a couple months, 2 months ago, right? Actually, back in August. And we made decisions on it, and there was a letter that came back requesting a reopen that we denied. And our reasoning was we wanted an offer of proof, because we would need something that would lead whoever was here to change their minds, because we would obviously be going back on a decision that we did, which would not only require a 5-0 vote to reopen, but also a 5-0 decision to change anything. So we felt it was important for everyone to have at least the information to see if they would consider changing their decisions based on that offer of proof. So I guess we can open it up for discussion if anyone wants to talk about, you know, everyone's familiar with the case. I believe it was, let's see, Adrian, myself, John, actually, we were all here, all 5 of us. So if you guys want to discuss, did you see anything in that letter that would lead you to?
This was the outdoor storage.
This was the outdoor storage. You remember it was an existing outdoor storage. There were some things that they wanted to change, some things that they wanted to keep the same. They were, actually, it's up on the,
Double driveway or something. increase the
I believe the driveway was a concern. The height of some of the
Fencing.
storage bins.
Isn't fencing too?
I don't think we can take anything from the audience. So you want me to read through so that everyone's familiar? I'll read the letter for the record. Dear Chairman Benz, we are attorneys for CPIOS Acquisitions, LLC, the contract vendee of the referenced property. We appreciate the opportunity to resubmit our request for a limited rehearing of our application, the decision for which was issued on or about October 1st, 2025. The BZA decision adopted all of the recommendations of planning staff as set forth in the August 8th, 2025 Planning Advisory Report. Unfortunately, we did not receive a copy of the planning report in time to meet with planning staff to alleviate their concerns regarding 3 specific variances. We are therefore requesting a rehearing of this board's denial of applicant's request for these 3 specific variances. And they are as follows. Variance 1, increasing the maximum height of a fence from 6 feet to 10 feet. Initially, we sought a variance to increase the maximum height of a fence wall berm from 6 feet to 10 feet. However, we revised this request to seek this variance only with respect to existing walls. The walls in question are made of stone, such that their reduction to 6 feet would be extremely costly. Moreover, the height of the walls in issue, save one, are a de minimis amount over the required 6 feet, as shown on the highlighted plan submitted to this board at your request. That's a copy of which is enclosed. The wall heights are 6'1", 6'5", 6'1", 6'9", and 6'5". There is also one wall that is 8'9", but cannot be seen from the perimeter of the site. Given these small amounts of over 6 feet and the cost to shave off these amounts from a stone wall, we believe this variance should have been granted. Variance number 2, we are seeking reducing the minimum required parking from 56 to 30 spaces. We are seeking a parking variance to reduce minimum parking from 56 spaces to 30 spaces. As this is an outdoor storage facility, the number of parking spaces that will be used is well below the 30 spaces provided. Indeed, it is somewhat akin to a self-storage warehouse where items may be left for long periods of time until they are needed, thus requiring a much lower number of parking spaces. This board, in case number 18971, while granting special permits for a trucking station and outdoor storage to property located at 2 Old Northport Road, also granted a parking variance from 48 spaces to 30 spaces, quite similar to the variance we are requesting. It is also important to note that the layout set forth in our site plan is conceptual in nature, as it will ultimately be determined by client need. Planning had asked us for a proposed layout, so we came up with one that would maximize, if you will, the parking variance needed in order that we do not have to come back before this board every time we signed a new tenant. Therefore, the actual number of parking spaces required may prove to be much less. Variance number 3, reducing the minimum width of a drive aisle from 24 feet to 22 feet. The particular drive aisle in question is located on the north side of the property. The planning report adopted by this board recommended denial of this variance in order to provide adequate space for two-way traffic. However, given the nature and use of this site, it is the extremely rare occasion that cars will be traveling both ways on this drive aisle at the same time. Again, that this is an outdoor storage site, not a bustling office or warehouse. The cost to add the extra 2 feet of drive aisle, when the goal stated by planning won't be affected by the addition of these 2 feet, simply doesn't make sense, and this variance should have been granted. On a related note, we would request that condition number 4 be modified to delete drive aisles and pavement. The northerly drive aisle in question presently extends to the property line and has been in existence for years. A condition requiring applicant to have this drive aisle meet the minimum 6-foot setback would require the costly ripping up of approximately 5,640 square feet of pavement and shifting the drive aisle south by 6 feet, which would alter the entire site plan. Based on the industrial nature of the entire area, as well as the fact that the owner of the abutting property to the north also has materials extending to the property line, this condition should be modified as requested. Based on the foregoing, we believe that specific circumstances exist that warrant the approval of these variances. We therefore request a rehearing with regard to these specific issues at the board's earliest convenience. At this rehearing, we are confident that we can demonstrate that all 5 factors set forth in Town Law 267B weigh heavily in favor of granting these 3 requested variances. Should you have any questions or require additional information, please feel free to contact me. And then behind that is the actual site plan with highlights.
Yeah, that was sent to us.
Correct.
Reading it.
So the question becomes, in taking in that information, A, do you feel it's enough information to warrant a rehearing? And then B, ultimately, it would be the entire board that has to agree to that. So I guess, what are you guys thinking? Because all 5 of us obviously vote on it. And I did have a question for either planning or the town attorney. If we do vote to reopen, and then we rehear this at a later date, and the board changes, it would be a unanimous of the members present, even if one of the people isn't on the board at that time? At that hearing? Okay. We don't have to bring them back in. Anyway, do you guys want to discuss, you know, what you've heard what the requests are and what the changes are? Do you feel that it's enough to reopen? Not, forget what your decision would be. Do you think it's enough to reopen it to hear it again? Anyone?
My feeling, I wouldn't be opposed to reopen it for them.
Okay.
I
John?
don't know if it'll change my decision, but, I mean, if they want to state it, and they have other cases that they said, I wouldn't be opposed.
Okay.
Hey, Dave. I don't think she heard you.
Opposed.
Adrian?
Sorry.
Yeah, all right, I'll go along opposing it.
Well, do you have concerns? Or?
I do, I don't think I'm going to be changing my vote, so,
Well, I guess it's a two-part question. One is, not necessarily that you change your vote, do you feel that there's enough information there, the warrant, that you would want to hear what they had to say?
I would give them the opportunity to come back.
And I guess my question would, another one, sorry, to either planning or the town attorney is, if in the request to reopen, if there are certain items that, you know, I personally believe that in a couple of them, there's information that, you know, I would consider, but if one of them I didn't, do you reopen the entire application, or how does
Yeah,
it
how do
work? The entire application gets reopened. Okay.
But they're opposed, so it has to be unanimous, doesn't it, to reopen?
No, they were in favor of reopening.
Oh,
I'd hear it,
I
I don't
believe,
know if I would
yeah.
change it.
Yeah, I don't know if it would change.
Yeah.
yeah.
Be open.
But can we just reopen what they're
What?
asking?
Like you said, Tony, you don't get to that question tonight. Just to
So we could theoretically reopen it and make it worse on it. I just wanted to clarify that. Okay. So Adrian, you would want to reopen?
Yes,
or-
I would.
And then Gay?
Yeah, I think that with all, reopening the application is fair.
Okay. So I will also vote to reopen next December.
You're busy.
whenever,
Well, what does January look like?
it was filling up. I didn't take a look at it this week. You could do the second January meeting if you want.
We pushed a couple from tonight to the first one, right?
Yeah, we did a couple to the first one. We
So
definitely.
let's do it on the 27th, so we're not here till midnight. That way we can,
I believe you have to do everything all over again, yeah.
okay, so we're adjourned. We're gonna reopen case number 19368 CPIOS Acquisitions LLC, and hear it at the January 27th meeting.
27th.
All right. And I believe that is all the work we have to do for this evening, right?